One. Perfect. A very good morning to one and all present here, and I am glad to host this second edition. And the first time, I think I have a co-host as well, Ananya. Thank you so much for joining in. We have an illustrious list of speakers, but this is the second summit. This is the second edition, and I mean, we're not here to talk about how glorious the first edition was. Maybe just a little bit, but not too much into the details. But yeah, the National Legal Summit 2.0. It promises to be a riveting experience filled with stimulating debates, insightful discussions, and the exchange of innovative ideas. As we today delve into topics like AI, ethics, and legal implications, obviously, alongside the Uniform Civil Code, for which we have our panelists here, let us remember the wisdom of Abraham Lincoln, who said that the best way to get a bad law repealed is to enforce it strictly. A reminder that laws we create have a profound impact on society, and thoughtful deliberation is obviously key. As we gather here today, I can't help but also recall the words of Mark Twain, who once quipped, "The more you explain it, the more I don't understand it." Well, fear not, my friends, for we shall endeavor to make complex legal matters comprehensible and captivating even for the non-lawyers amongst us. Even though we are calling this a National Legal Summit, I'm proud to announce that guests from around 5 countries have joined us, wherein organizations that have their bases set up in around 12 countries are a part of this esteemed National Legal Summit. We'll go on to introduce the speakers for our session today, which is on Uniform Civil Code, and it's really good to see everyone alongside here. Everyone has their videos on also. Before I introduce the speakers, I'll just lay down certain ground rules. So certain things need to be kept in mind, especially because ये virtually हो रहा है, and I'll keep switching in from English and Hindi because there is a certain audience which is not familiar with the language English a lot, and that's fine because language is no barrier for us. एंड मैं हिंदी और इंग्लिश दोनों में बोलता रहूंगा. आप किसी को भी अगर कोई दिक्कत होगी, इफ यू हैव एनी प्रॉब्लम इन अंडरस्टैंडिंग व्हाट आई एम सेइंग, यू कैन आस्क अस और यू कैन ड्रॉप अ comment in the chat box. Please don't interrupt any speaker while they're speaking, even if you have a question. Please keep in mind that only the speakers are supposed to have their video on. If you have your videos on, I think someone has enabled closed captioning. So if you have your video on, make sure that you have a question in mind and make sure you're not moving around or causing too much disturbance into the setup, because then we'll have to either, remove you because it'll be very disruptive. So we hope that you'd respect the decorum of the summit, even though it's happening virtually. And it's perfect because we live in the digital age and we have a topic for that as well, AI and, information, how the digital intelligence is working around. And for people who've been watching this edition, so this is basically a part of Open Floor with Nihshank. We have brand associations this time, and we have beautiful sponsors. I am live from Laghu Udyog Bharati, New Delhi, with my co-host Ananya, who will speak shortly in a while, because I'm going to take up some of the time in the beginning. But we have Laghu Udyog Bharati on board, which is great. We have Bharati Section Mandal, very important organization when it comes to education, having the Prime Minister in one of their few sessions the last time. And we also have Gambit Enclave, startup on my behalf, who's associated with this. But let's talk about a little about our sponsors because, kind of you have to. And also because they're really cool people. So NYARO is basically, ladies and gentlemen, we are thrilled to have NYARO as one of the esteemed sponsors for the National Legal Summit, a brand that epitomizes the sense of new and nice and is here to bring out the drop dead gorgeous diva in all of us. Now, I know it's a clothing brand, and that is how far our ecosystem has gone, to collaborate with people. It is led by the visionary designer and creative head Anchal Ahuja, which we need to who we need to thank today, and also thank Ananya for bringing her on board. NYARO has carved a niche for itself with its collection that are hailed as timeless, dynamic, and graceful. With over 15 years of experience in designing for leading fashion brands of the United States of America and Europe, Anchal brings her passion for indigenous craft and love for experimenting with embroidery techniques to every NYARO creation. And thank you. I'm thankful for you to sponsor this. And now let's go on to our speakers. I'm sure everyone is excited to hear a lot about them. I mean, we sort of, okay, so just to, for the speakers to know, we already had sort of a group for the participants, right? And we sort of enabled them to ensure, we sort of enable them to let you know about whoever is coming and whoever is on board. So they already sort of have a brief about you. So I'll keep it as short and simple as possible so that, we have this small introduction about the speakers and the speakers can get to know each other as well. And so first is obviously Senior Advocate Sukhjinder Singh Behl. And ladies and gentlemen, it is with great pleasure that we introduce one of our esteemed panelists at the National Legal Summit, Mr. Advocate Sukhjinder Singh Behl. So I said senior because we had accidentally written it down as senior, and that's a learning exercise for us as well. Because senior is more of a designation, right? And that is something that is awarded by the court. And so you keep it as advocate Sukhjinder Singh Behl, and that is something we are thankful for Sir to introduce us with. And we'll talk a little about him. So in the year 2003, Advocate Sukhjinder Singh Behl was appointed as the Additional Advocate General of Punjab, where he diligently represented the state government in matters concerning service, taxation, and land acquisition. And these are the bios that have been provided by our speakers, all right? So if it goes a little bit haywire, please feel free to correct us. We won't mind at all. And throughout his journey, Mr. Sukhjinder has held various leadership roles within the legal community, showcasing his dedication and commitment to the field. Notably, he was also elected as the secretary for the Punjab Haryana Bar Association in 1998 and 99, followed by serving as the vice president and acting president in 2002 and 3. In recognition of his capabilities and achievements, he was later elected as the president in 2009 and 10. And if you're guessing it, that I'm reading it out from somewhere, you are right. Absolutely, because there is so much to remember with respect to the bios. We have advocate on record. This is Niharika Ahluwalia. Ladies and gentlemen, it is our privilege to introduce another distinguished speaker at the National Legal Summit. Ms. Niharika Ahluwalia, with an exceptional legal career. Ms. Ahluwalia is a prominent figure in the domain of law, serving as an advocate on record in the Honorable Supreme Court of India. It's a pleasure to have you on board, ma'am. Her proficiency in handling complex legal matters before the Supreme Court and the high courts across the country is a testament to her expertise and dedication to the legal profession. And as an advocate with extensive experience in constitutional, corporate, civil, and criminal laws, Ms. Ahluwalia has been a pivotal face in advocating justice and upholding the principles of law. So I'm glad that Ananya, you brought her on board. That is really nice. We have Advocate Anurag Singh as well. And he's got some extensive experience in both original and appellate sides of litigation. Advocate Anurag Singh made appearances in the Honorable Supreme Court of India, Delhi High Court, and various trial courts. His expertise in handling diverse legal matters has earned him a well-deserved reputation in the legal community. He's been continuously engaged in the legal profession since 2002, I guess, with a focus on both corporate advisory and compliance, as well as litigation. His impressive track record includes serving as panel counsel for the Union of India and the government of Madhya Pradesh in the Supreme Court of India. Back in law school, we always used to hear, no, that this is Union of India versus this. So I always thought, what is the panel counsel? Who exactly is representing these people? I'm glad we have one of these people on board with us. So that is really exciting. Additionally, he has also been associated with esteemed organizations like the Competition Commission of India and the Railway Claims Tribunal. Pradosh Kumar Mohapatra sir is also there. He has his journey in the financial sector since 1978. So that's more than 37-year long career in the banking sector. And he'll be the one who will be trying pitch in and ask you the right questions. He's also served as the general manager of Federal Bank, if I'm not wrong, and I'm sure left a lasting impact on the organization's success. He's also the head of NBFC, I guess. And I'm really, really happy to have you on board, sir. And finally, last but definitely not the least, Mr. Kushank Sindhu, who currently serves as the partner at Sigma Chambers, advocates and solicitors. His remarkable legal career is a testament to his dedication and expertise in the field of law. As a licensed lawyer, obviously, Kushank's journey in the legal profession has been nothing short of extraordinary. Having worked with esteemed firms such as L&L Partner Law Officers and the ICICI Bank before starting his own firm, so kudos to you for that. He's honed his skills and acquired invaluable experience in corporate advisory, transactions, and litigations. Now, I have introduced the speakers. We'll also put out the complete bios in the chat. And I'm really excited what Ananya has to say about the topic, because then we'll directly delve into the panel discussion. Okay, so for the panel, I think every speaker will have an opening statement for around 2 to 5 minutes, based on which we'll ask a few questions. And if someone has questions from the chat, they can already pose it in the chat as well. And we'll take that questions on board, followed by which we'll move on to the next speaker. Every speaker will get to make their opening statements, followed by which the floor will be open for discussion. This will move around in a round robin format, so that every speaker gets to at least first make their point. And what is really different with these media agencies hosting this National Legal Summit, and not to really be, not to really flex, but we are not really biased. All we care about is, the All we care about is the legal community. We care about how we are shaping such things such as the Uniform Civil Code, the impact it has. And the best part is that I don't have to shout at the top of my lungs to support one party or another, right? So this is not for the parties, this is for the people. And I'm glad that all of us here are on board. Ananya, you can take on the floor from here because I think I've spoken too much. Yeah.
We're extremely thankful for your presence, and it's a pleasure to have you on board. So first of all, I would like to thank all of you to join us today, and also thank our parents who raised us the right way and gave us the education so that we can host the summit today. Now I'll be talking about the topic that is UCC. I'll be introducing the topic, and then I'll open the floor for the speakers to begin with the discussion and put forward their views. So I'll start with the quote because apparently that's the right way to go about it. But yeah, so Mahatma Gandhi once said, "I do not want my house to be walled in on all sides and my windows to be stuffed. I want the cultures of all lands to be blown about my house as freely as possible. But I refuse to be blown off my feet by any." With that, we begin the discussion on UCC. The UCC is a contentious and complex issue in India, calling for a common set of laws governing personal matters for all citizens, I would say, irrespective of their religious affiliations. The debate over UCC has raised important questions about secularism, religious freedoms, gender justice, and minority rights. And these are some of the topics that we'll be talking about today. Um, After all, UCC is also mentioned in our Indian Constitution in Article 44 under the DPSPs. It is intended to promote gender justice and social cohesion. However, the implementation remains a subject of debate, especially concerning its impact on the rights and customs of indigenous tribal communities, who fear their potential erosion of their cultural identity and traditional practices under a common civil code. Also talking about, I think it is very important to bring in the cases of Shah Bano and Shaira Bano here, and the journey has indeed been a difficult one. The Shah Bano case in 1985 and the subsequent Shaira Bano case in 2017 played significant roles in highlighting the need for gender equality under UCC. While the former one brought UCC debate to the forefront, the latter emphasized the urgency for gender just reforms by declaring the practice of instant triple talaq unconstitutional. Also mentioning a few quick points about minority rights and gender equality. The implementation of UCC raises concerns about its potential impact on the rights and customs of indigenous tribal communities, as they have distinct personal laws and customs governing their social and religious affairs. With careful consideration, I think we should also take them into picture and think about them, whether UCC will be beneficial for them in some or the other way. Now I'll open the floor for our speakers, and the question that I'll put forward to them is whether UCC is desirable to begin with.
All right. Thank you so much, Ananya. I think, is it okay if we start with Niharika, ma'am? Ma'am, is it okay if we start with you? Also, ma'am, before you just start in, so okay, her mic is off just to avoid echo, you understand, because you're just shooting from the same place. So in case, you guys have any discrepancy in hearing her, you can just let us know and we'll let her unmute, all right? Yes, ma'am, you have the floor. I'm really excited
Thank
to
you,
hear what you have
Nihshank.
to say.
Thank you. Thank you. A very good morning to Nihshank and Ananya. Thank you for having me here, and a very good morning to my fellow panelists. For all the advocates here, I can say it's a Saturday and we are all here before 10 o'clock. So that's quite a feat to both of you for getting all advocates here on a Saturday. But quickly coming to the point, because I know everybody will have a lot to say on this. Like Ananya said, it's one of the most contentious and one of like what they call a hot debate on prime time nowadays. So as Ananya put the question, I think she said, is it really desirable? So I'm going to straight away answer that. I want to first ask myself, what is UCC? While, when Ananya sent me the invite, I had the time to go online and check what the Law Commission is really inviting comments on. And as it turns out that there is no policy or draft out there. So my question to myself, and maybe my fellow panelists can chip in because they're far more senior to me and maybe they know more. What is it that we as citizens Forget lawyers. What are we really commenting on as students of law, as stakeholders? I, for one, could not find a draft. In 2018, Law Commission had put out a consultation paper where they wanted to kind of codify family laws. But again, we today, besides this being really a political issue, I don't know if it's an election agenda. I don't know if how far we are really going to implement this because of a directive principle. But what is it that we are looking for? And I think only after that can you answer whether it is desirable or not. And as a question, as I understand it, is do we want a uniform civil code, which maybe in layman language means, and or how I understand it from time immemorial, is we want a uniform rule of law which will permeate or rule the personal lives sans religious connotations, which means that the personal religious law takes a backseat, or will it be completely repealed, or will we get in amendments to tweak what we find to be undesirable, not gender neutral, or discriminatory. So for me, where we stand today, it is extremely, extremely vague. What would be more desirable to get a uniform law which starts from a blank slate and we build up from there? Or would it be better, like she mentioned, the Shah Bano case, the triple talaq, where the judiciary has stepped in, maybe the legislature steps in and starts amending these personal laws, and we have a gradual rolling factor of how we take these in. And probably for somebody like me, I think find the second to be more desirable, one for lack of draft right now. And second, also because we're such a diverse and culturally vibrant society, a religiously vibrant society. How do we get on board all stakeholders? So it's definitely a big challenge for any legislature. And this is a challenge which actually, I think, prompted the Article 44 to remain as a directive principle, as a non-justiciable right, and not a fundamental right. And if you go back to those debates, this question, in fact, was posed in the Constituent Assembly way back in 1947, when K.T. Shah asked that when we talk about, this was then clause 39 of the Uniform Civil Code, and it simply read that the state shall endeavor to bring about a uniform civil code for all its citizens. And K.T. Shah asked that we must have some founding principles from which we will understand what a uniform civil code is. And he gave an example. For example, marriage is going to be a contract of monogamous character where both partners will have equal rights and duties. Now, I frankly, way back in 1947, find this to be the most beautifully worded definition because it is gender neutral, it is religion neutral. However, what this does is, my first blush when I read this was this offends two religions straight away. A majority religion, which doesn't look at marriage as a contract, and a minority religion, where monogamy may be practiced very actively, but polygamy is recognized. So do we get on board two stakeholders, or will the government or will the parliament have it to put forward, ask the majority to accept this as a contract, and ask the minority to give up polygamy? So today I feel what we really have is more questions. But if you ask me as an egalitarian citizen of an ideal society, do we want a uniform civil code? Of course, yes. It improves access to justice. It improves interpretation of laws. There is more uniformity. On the face of it, it feels like there will be more equality. Of course, these will have to be tested over time. Access to justice, I feel, may improve if we have uniform civil code, because you will not have certain sections of society left out, wanting for lack of awareness as to what the laws are currently at the moment. But there is a lot to be said about all of this yet. But these are just my opening remarks, and I leave it to the panel now.
Right, Anna, you have a comment to make. You were listening very carefully to what ma'am had to say. Yeah.
Yeah, so ma'am summarized it really well. She started by mentioning that there is no draft at hand, and Law Commission has just simply asked us to comment on whether there should be a UCC. Also, she highlighted very well the definition given by K.D. Shah, and I was not aware of it, and it is a really beautiful one. I completely agree on that. So I am, and also I think she very rightly put that it might take a toll on personal laws, but let's see what it brings, and we'll have to give it some time to test it, and to figure out whether it is a good one for India or not. What do you think?
Right. Yeah. No, I get what even ma'am is saying, what you were saying, and summarizing it. And this is exactly, I think, Kapil Sibal. What Kapil Sibal said when asked in the Times Now interview, exactly as to what exactly we are debating on, because there needs to be a draft that needs to be on the table for us to ensure what kind of deliberation we are headed into. But let's not be completely unaware about the fact, or even give other people the benefit of doubt that there is something that is going on in the mind of the government. You realize that the law is as good as the implementers, all right? And the intention behind the law matters as much as the implementation, as to who's implementing the law. So let's look at this from the perspective of three agendas that the current government had in mind. Firstly was 370, secondly was Ram Janmabhoomi, and third is UCC. The debate sparked off when after the law commission, the prime minister came in and addressed the demand for UCC, and therein wherein we again got into this mode of discussing about the Uniform Civil Code. But I think ma'am is right in understanding and pointing out that we really need a structure as to where exactly we are headed to. And I would like Mr. Advocate Anurag Singh to come in here and really brief us about his opening remarks on the topic at hand. So do you agree that we still need to figure out an agenda to go, or do you believe that we already have a sort of set understanding of what the Uniform Civil Code is, and we already need to sort of start debating and taking the right way ahead? Anurag sir, please.
Good morning, everyone. Personally, according to me, as a lawyer, it becomes very difficult when you have a confused mandate. And Uniform Civil Code to me is a confused mandate being represented by a government which calls itself a product of the democratic process, but has very clear religious divisive agenda. That's my personal opinion. And I say that because not just two religions, which Niharika very rightly pointed out, and I'm thankful to her for giving me the perspective, because today in the morning I was totally clueless. What will I be speaking? Because you have nothing on the palette, nothing. There's nothing, absolutely nothing. And Mr. Sibal very rightly, as a lawyer, perhaps, not as a representative of any political party, pointed out this to Navika Kumar, that what is there to debate? There's nothing. Now today, suppose you take out the tribal culture of India, which is very diverse, be it Jharkhand, be it in Northeast, be it in Karnataka, be it in Tamil Nadu. I have no idea about Kashmir, but some parts of Rajasthan. They don't want to be part of your civilization. They refuse to acknowledge your air conditioning culture. They refuse to acknowledge your environmental culture, which is very much destructive. We are going back to organic culture. And then you will bring this Uniform Civil Code, where you will say that, look, I will govern your life and livelihood things. I will govern how will you marry, how will you conduct your personal relationships, how will you solve your property disputes. The list is endless. So I guess what we have at hand today is nothing but a hodgepodge of nothing. There is no ingredient in the menu, in the pot, where you can single out issues that, all right, as a democratic republic today, which the constitution, which guarantees us, this is very oftenly quoted by lawyers, so please excuse me for that liberty, equality, and fraternity. And UCC to me is fundamentally, totally against the fraternity thing which we have. Because fraternity means even if you are not with the majority view, you have a right to belong to that society. You can't be threatened because some law is going to come which is going to take my personal right, because some tribals of Jharkhand, some tribals in Northeast, you have different CRPC also in Northeast. Not Jharkhand, but in some parts of Tripura and all those corner states. Recently, we are seeing this violence happening around in Manipur. That's also, I don't know why so much of, there's not debate on that. But since that's not our topic, the point which I'm trying to make is that when you talk about equality, the first thing which is important is the view which that individual has as a dissenting individual in that part of segment, be it religion, be it caste, be it tribe, be it anything, any portion of the society. And perhaps taking care of that was the motto of our constitution makers. That is why they brought this not as a debatable or claimable right. They brought it as a principle where the society at large can debate it, and they left it to the wisdom of the society. And for us today, we have to understand that if, yes, I can think above religion, yes, I can think above region, I can think above caste, I can think above color, I can think above a sexual orientation, I can think above this male-female divide and other genders, then only perhaps something would come out in the Uniform Civil Code. Else, I guess it's just a political gimmick, nothing else.
All right.
I'll be
Okay.
concluding there.
Yeah, thank you, sir. I see very strongly people feeling about, that as to what exactly are we headed into when we're talking about the Uniform Civil Code. And I think since no one's countering, I think we'll counter as hosts because we want to, put in the points on the other side also, because obviously, again, not a national media TV channel. Anna, you had a question. You can chime in and then I'll ask mine.
Yes, sir. One of the questions that came to my mind was if I also mentioned that in our constitution article 44 UCC is mentioned, and it comes to us like our forefathers wanted this, and it was a constitutional mandate given to us by our constitution. What would you comment on that?
Right. And I'll just add into that question, sir, for you. And I think even Niharika ma'am can take this in, and then we'll move on to the next speaker for their opening statements. Ma'am and sir, the real question here is that you understand that there are different laws that are at stake, but all these laws have their own problems, right? If I would ask this question, like I discussed this with a member of parliament, what they had to say is that every law, like she mentioned Shaira Bano and Shah Bano, and whether you can talk about the Christian law, you can talk about the tribals or whatever it is. There are certain laws that have their own biases, and they have their own problems, right? Like for the Parsi community, it took 26 years for them to finally get a Supreme Court judgment in their favor as to extract the right to have belief in their whatever faith they want to practice. So at the same time, when we're trying to ensure the rights of the minority and we're trying to protect the rights of the minority, let's not forget that this Uniform Civil Code is not a garb to crush the minority, but in fact it is there to inherently just remove the discrepancies that exist, and on the basis of which there is clear discrimination for especially women within all sects of the law. And I'm not talking about any particular law in general. It's there in the Hindu Marriage Act. It's there
Absolutely.
in the Muslim personal law. So just a quick comment on that by both Niharika ma'am and sir, and then we'll move.
In fact, I had a similar question for Anurag sir. What Nihshank is putting forward, and maybe Anurag sir can answer that. When he was speaking of fraternity, he said that what this would essentially do is take away the personal laws of minorities. But then that begs the question that we still don't know what is going to be the template of this code. Is it going to be a majoritarian law and then we build up from there? Or like I said, is it going to be a clean slate? We don't know that yet. Also, we are presuming that it's going to take away from a minority. I don't think that has been put out like that. What I also understand is that there is a proposal that the customs are still going to be protected. So I don't think they initially want to bring in an absolute uniform civil code, because uniform would then cannot protect customs. For example, I know there are customs in Punjab which govern inheritance rights. I don't know if those will be protected or only the northeastern customs being protected. But not to ask more questions, but maybe Anurag sir can pitch in. I personally don't think it will take away fraternity, because we are acting on a presumption where we are mixing the political agenda with
Right.
what the Uniform Civil Code may be.
Right.
For example, when the subcommittee on the minorities was sitting while drafting the constitution, this was a genuine fear. So what they did is they had, I think, about 52 members of the minorities, 52 representatives of different minorities who were allowed to pitch in. So maybe once there is a draft, once minority communities and stakeholders are allowed to pitch in, we cannot say right now that it would be taking away the fraternity, because also we don't know how deep we would be going into this. Like Nihshank said, for all we know that we may be protecting the minority communities. We may be taking something away from the majority communities as well. So I think it's too soon to make this a debate into minority versus majority. Although I do understand that the underlying fears of minority communities since 1947 have been relevant and they remain relevant even today. But I don't quite understand how it impacts fraternity for us as a nation. And that's my question to Anurag.
I think let's hear Behel sir first, and then I'll
Okay.
get back to Niharika's question.
Okay.
great.
Also, I think sir sort of logged out for a while due to bad cough or something. So if you, sir, if you need the reframing of the question, because I think you missed out on the first part, do let us know. I'll do that as well. Okay. You have already said it, so let's go. Let's go to Sukhjinder sir, and followed by Kushank. I'm also waiting to hear what you have on board. But I think very interesting questions have been raised, and this is something we need to you need to understand and look at it from both sides, right, Ananya? Because we can't really have just a forefront approach on that is completely bent on one side. Yes, sir. You can have the floor now for your opening remarks. So you are on mute. Yes, sir. Go on.
Good morning, everybody. I'm thankful to both of you that you asked me to join you. It's a pleasure for me. And as Madam Niharika as well as Anurag sir has already given their opinion, my perspective is that change is a law of nature. If something is not done earlier, this is never be late. With certain riders, because whatever the Uniform Civil Code has been brought in the Constitution, this debate is lingering for the last about 30-40 years, right from Shah Banu's case and subsequently also. So it is not that this is something new. My personal opinion is, I may be wrong, that the government, it is the right time. It's a high time. There is something is we have to done. If some people are illiterate, some are not able to understand the veracity and the meaning or the impracticability. So sometimes something is to be done. Now it is the time by keeping, because everybody has a personal right. The Supreme Court has, the Constitution has provided us the prospective principle. So when something is to be done, there is no doubt that hue and cry is, because of the certain reactions are bound to happen. But keeping in view the reactions and by going through the deepness into all these facts, what are the factors, ultimately the improvement is to be made. My personal view is that no doubt it is the personal rights of the person, but still we are living in a country, we are living in a society. If we are not able to, supposing, I've just given an example to myself. Supposing I feel that there is some improvement, personal laws, every religion has a personal law. Guru Granth Sahib was creation of Guru Gobind Singh Maharaj. It was written by various gurus. I'm just giving an example, being a Sikh, I know it. But still, I am a Sikh by birth, I follow the practice. So there are certain things. Now, from our religion, many persons, those who are not, because of these kind of things, we are not able to control them. Now, trimming is common, haircut is common in Sikhs. So these things, if we bring a uniformity, if we are liberal at some point of time, maybe we are able to change the old school of thought. So therefore, with passes time to time, things should continue to improve. And at present, if this civil code is brought, it is introduced with certain riders. So there is no harm in doing it. There is nothing as such which is called personal. And under the concept of that personalization, if we are going to not help the society or improve the society or at large, so ultimately we will not be able to improve ourselves. If I agree to Anurag sir, no doubt about it, that in Jammu and Kashmir there is no CRPC, they have their own law, and no doubt about it. There are certain parts of the country. Then why we say that it is independence? After 75 years of the independence, if still we are standing at the same space, what kind of I'm sure that my friends and all of you have better experience of the other countries where there is so simplification of law that if you do it, then you have to do that. Simple. Plus one is 2. There is no if and but. But in our country, unfortunately, I would say that our constitution, which is the beautiful, I would say, proudly word, but still, because of the if and provided, we are not able to achieve what we wanted to achieve. After 47, we gave the privilege clause what you call that, the some certain privileges to the scheduled caste, this, that. Now, after such a long time, still those who belong to but maybe from scheduled caste, their generations are having the UPSC, everything is there. So what kind of reservation is that? We must change according to the time.
No, absolutely. I think your points are very well taken. I can see Niharika ma'am shaking her head as well. I think there's some sort of an agreement there. But sir, okay, also since you talked about the 6 in, there'll be a great, if you could, okay, what exactly would happen to the Anand Marriage Act for 6 after UCC, right? It would be like shooting in the dark if we were to say that UCC doesn't affect the 6, like especially when BJP has an absolute majority. So I'd like a quick comment on you from that. And then Ananya, I think you had a question, so we can move on to that as well.
Yeah, not only 6, if, other speakers could chime in and, they could comment. Also, if you think about the Muslim law, Sunni and Shia law, there is a distinct gender biased imbalance, right? With women entitled to only half the inheritance that men receive. Also, if we see the Christian law, so in Christian women under the Indian Succession Act inherit only 1/3 of the property, although sons and daughters share their parents' property equally.
Yeah.
So, what will happen to all these things? Will they all be inculcated to a single code and a single law will apply to all the religions? And, are we trying to remove the disparities that way, or what would be your comment?
Absolutely. Yes, sir,
yeah.
please. Yeah.
No, with certain riders, I again say, with certain riders, these things could be improved. You see that if in Christianity, in Parsi, so far as I remember, that if a male member marries to the non-Parsi, then his property is not being given to the child. So as both should be Parsi, only then they can take the inheritance. If we know, we can understand. We are now an improved version of our society. Our forefathers was not so blessed that what we are enjoying today, they were not having the things which we are having, technology, from all aspects of the life. So why not to change that? It is not forcing the civil code. It is with the consent. It is ultimately for their benefit.
Okay.
I'm not supporting any political party. I'm not the last person to be joining either A is right or B is wrong. I'm just thinking as a citizen of the country. My concern is for the country. I'm not for A comes, B goes, both are equal. I have nothing to do with this government or previous government. But I want to contend is, my submission is, my thought is that we should improve ourselves, our society, our religion, our circle. To some extent, if we are rigid, then what would happen? Earlier, under the Hindu inheritance, the girls were not given the share. Right. There was a logic also. There was a logic for not giving the share to the daughter, because earlier, after I can say that 100 years or 200 years or 50 years, even after partition also, there were family was bigger. It was not nuclear families like this. There were bigger families. And when the girl child was born, the parents have to spend a lot of money for marriage. Then thereafter, whenever there was some function in the daughter's in-laws side, then they have to support them financially. Then again, when the child is to be born from out of that daughter, she would have come to her parents' house and they will do everything. Then after they will drop her. Then on every occasion, every function is to be properly taken care by. So it was the reason that they don't give this share. This is what I feel. I may be wrong also, but I am my own opinion. Right. So for that reason, they may be thinking that since the daughter is a permanent liability for us, so no share is required, because every year we give some share to the daughter in one way or the other. Now, in the nuclear families, things have totally shattered. The society is going to be bad to worse, I would say. Now, if a real sister has to go, normally there are children or one daughter or one son is there. And if the sister has to visit her parents' house, she will have to intimate. My own experience. If my wife goes to my in-laws house without information, they are doing their own business. They would be totally disturbed. Maybe every reason, be reason. Earlier, this was not the situation. So ultimately, the society has improved. Now the daughter is equally entitled to get the property of the father. I don't say there is nothing wrong in it. Why not the
Okay.
society to improve?
Right, sir, but just to like, so you said like the logic about daughters being liabilities. So you do not conform to that logic, right? You do not agree to that logic. And you believe that we have evolved from that and that is the right way to go about it. If like I got the statement correctly, right?
Please.
Yeah, definitely. Okay, because I was like a little taken aback at that because obviously the logic is flawed. I mean, that is what we've been deliberating for. Even though 2005 you had the co-partnership rights being included, it takes literally like 15 years to actually get it on ground. And that's the problem with most laws. Kushank, I think you can come in here and we'll again go back to this question about the different kinds of religions that we're dealing with. But before Kushank, before I can come to you, so there was a question about the Anand Marriage Act, right? And I posed it in front of you. Since you talked about the Sikh community, if you could just enlighten us in very short, what exactly would happen to the Anand Marriage Act? It's a very important part of the culture, right?
It's in certain states it has been applied.
मीटिंग करा रही है दिल्ली च सारे वकील आए हैं जज आए हैं लक्की बोल रहे हैं
I think someone has just
लक्की भैया
can you I think uncle is speaking. Guys, these things will keep on happening. Just mute him out. Yeah, it's done. Perfect. That's not an issue. See, this is a part and parcel of the digital thing given.
Yes. And
so I hope you guys don't mind. But okay, I'm glad we got this in recording.
This is the beauty. This is the beauty. There can never be a uniformity, remember.
No, I mean, till now, I mean, we're going pretty good, but I'll take your point, sir. Kushank, yes, you can come in after this. Please go on.
We now Nandakarch Act has been
Okay.
implemented in certain parts of in Punjab is partially followed. In Chandigarh, we have the notification recently from 1st of July. In Chandigarh, we have been started following it. There is nothing much wrong. It is only the practical things which everybody is happily following it. There is nothing wrong in it.
Okay. Listening to Mr. Sukhjinder makes me believe that there are no problems at hand as well. But Anurag sir, you had a very contradictory view. I would like you to take it on later. But thank you so much. Yeah. Thank you so much for your statement there, sir. We'll move on to Kushank. And we'll just mute you if that's all right. Kushank, please go on.
Right. Thank you, Nihshank. Thank you, Ananya, and the other panelists. The advantage of coming after 5 stalwarts is that you get to know what the majority view at least is, what the minority view also is. So I'm glad for the very enlightening views. See, my concern, and this is coming back to the original question that we are debating, and that is the UCC per se, and not going so much into what individual laws or individual acts have to say. My concern is that the debate should not be, and I'm not saying it is, but I'm saying the debate should not be too much constitution centric, because I understand obviously the Constitution of India is a sacrosanct document, but the laws, especially the Constitution, they do not operate in a vacuum. They have to stem from society, what the society needs, what the society is, and most importantly, do we understand society? That I feel is very important. The one very fundamental issue with personal laws across India is that they are not codified. Not all of them are codified. Obviously, you have the Hindu Marriage Act, the Hindu Succession Act. You have something for Muslims, Parsis, etc., etc. But there are thousands of customs. There are thousands of communities, not just tribal communities, but even within, for instance, the Hindu religion. You go to different parts of India, there are different customs being followed at the local level itself. And how much of practical visibility do we have on all of this? Has there any study been done to possibly document each and every community and each and every custom. I don't think it has been. I might be wrong. I feel that till we do not have an understanding completely of how all of these communities operate, you can't just, thrust the UCC on all of them and say that, all right, that from tomorrow onwards, everything we are throwing a blanket on whatever you have been doing. And now you have to do 1, 2, 3, 4, 5, and only then your, marriage is recognized or your rights and property is recognized, etc., etc. So till we have not been able to overcome that fundamental problem, I don't think it is possible for us to even, now comes the problem of the definition of UCC. That how then do you define the UCC? If you do not really have an understanding of the complexities of which the society itself functions. So that is part 2. Part 3 is what, has already been, highlighted to a very large extent. And that is a concern about, the minorities and the religious minorities, etc. But, one thing, interestingly, minorities cannot always be just between communities. Even within a community, there might be minorities. So what is the extent to which we first understand it, and then we are in a position to actually frame the draft of the UCC? The other aspect is the entire idea of codification and whether or not communities are willing to accept such an interference in their religious, in their religious texts or the interpretation of their religious texts. See, it's not just about, the majority saying to the minority that from tomorrow, this is what you have to follow. It is also whether or not the minority wants to even accept this kind of an interference. You know that after the Shah Bano, the Shaira Bano case, etc., etc., there was a reversal of the entire Supreme Court judgment, where then the law stated that the Section 125 CRPC will not apply to the Muslim community. So I'm not on the point of whether it is right or wrong, but it is about whether or not communities are willing to accept this kind of an interpretation in their, in their religious domains. Now the question is, if giving all this, maybe instead of going for a very drastic, and this is probably where we can actually help the government, that when you are establishing the framework of UCC, maybe instead of having such a drastic change from having absolutely no codification to relying entirely on religious experts in individual cases, you go in for a more comprehensive codification which recognizes the different minorities within a universal framework. Because again, there is no definition of UCC, so we can come up with our own definition of UCC. Let it not be such a thing that, okay, marriage will only mean if you do A, B, C, D things. Let it mean that, for all these religions, these are the foundations of marriage. If you have done these, then whatever you do after that, it is recognized as a custom. And that is how I think we should frame the UCC. So instead of going for this, drastic overnight changes, let there be an incremental change where we are able to bring societies together, where we are able to bring communities together, first on a common platform. Our basics are itself, I don't think they are very clear. And we are, imagining a world. There are certain people who feel that the UCC will say that there'll be a uniform way of understanding marriage, divorce, property rights, etc. I don't think that we have reached such a level where we can have such a uniformity across religions, across communities, across castes. The UCC has to recognize these different frameworks and yet bring everyone together. How that happens is what I feel we should advise the Law Commission for, and that is what I feel the government should be doing. So that is for my opening.
Right. And you wanted to summarize. Yeah.
I think Kushank sir has very well summarized all the arguments against UCC, and he has very rightly pointed out that we cannot go for a blanket law, and we cannot, and there are minorities within minorities, and as claimed by the opposition, BJP is a very pro-Hindutva driven party, and their ideologies and their manifesto has then and now showed it. So.
Right.
imposing initially the triple talaq thing. Even the Congress government realized that there was a huge human cry after Shahbano judgment, and the government came in and reversed the law. All these things have been there. We really have to think about, we have to frame it better. We have to
Right.
take in the views of the minority, and we cannot impose any of one majority religious beliefs on all the religions.
Okay, I think it's time for me to step in as the representative of the BJP government because I feel a lot of anti sentiments. Kushank, I have a couple of questions for you, and we'll then move on to Niharika ma'am and Anurag sir's quick statement on it. Niharika ma'am, I think in the starting only said that I don't think we should look at it from a minority majority perspective. When you say that is the minority ready? If I were to look at it, and I'll just make a parallel example, I mean, not to be taken seriously, it's like that cricketer, you have in your team who's, who's never ready to bowl. And then we keep giving him that benefit of doubt that maybe, okay, you can do well in the next match, and then it keeps on going, and ultimately the team fails. The question that we've been asking for the past 75 years is that whether we are ready or not. If not today, when will the minority be ever ready? Is my first question to you. Secondly, are not changes being made to the majority culture as well? Why are we seeing it as a minority majority debate? What we are trying to establish is not whether there is a certain set of customs that should be followed within the way the marriage has to be accepted. What we're rather talking about is, let's say, for example, polygamy. If a particular religion is allowing the space for 4 marriages to be accepted, that is something that we need to take into consideration. If the Indian Majority Act says that 21 is the age and 18 is the age for male and female respectively, then we need to take into consideration that people, irrespective of their laws, cannot marry beforehand just because they say that it is in their personal interest. When personal interests collide with the very interest or nature of the community in itself, then it is where it becomes a problem. Kushank, these 2 questions for you, and then we'll move on to Anurag sir and Niharika.
You know, see, when we talk about what the religious texts say, what the Indian law has to say, etc., what I feel is that, what the religious text says, you really can't interpret it in, you may in some cases, but in some levels, they might be beyond interpretation. I mean, the interpretation is stuck, that this is what the religious text says. You can't, if it says X, you can't say, no, it also says Y. So my point is that Indian law probably has to just recognize people who want to do things which are not possibly there in the religious text and give allowance for that. So that is one part of it. The other part of it is, and I think because it was my opening statement, I did not possibly elaborate on it. When I said that we are possibly not ready for a blanket law on things. What I feel is that there should be more attention which should be given to the more fundamental aspects of legislative drafting itself. Now, I would want to draw an analogy with the farmer laws which were enacted, which were then repealed, etc., etc. One of the criticisms, I'm not saying right or wrong, but one of the criticisms against the farmer laws was that possibly it wasn't really communicated properly to the society or the farming community for the betterment for which possibly it was enacted. Okay. Again, I'm not going on the merits of how good or bad the farmer laws was. I'm on the more fundamental point of that when you are drafting a law, you have to take the society into confidence. That is the entire purpose of having a public consultation. Now, that is where I think our attention should be. That, for instance, when the Law Commission is asking for its comments, which is, I think, a very good idea, there are people who are saying they want to extend the timeline for giving their comments. Why don't you have a more inclusive process of actually drafting the law and actually getting those comments on board? Reach out to communities, reach out to tribals, reach out to those people who are not really touched directly by the internet or who cannot see. Yesterday, I was reading something on the internet which said that even in Port Blair, the internet connectivity is bad. Now in Port Blair, if within India, if the internet community is bad, do you really expect somebody to know, everyone to know what the Law Commission is asking for and their views to be given? The process of law formation has to be more inclusive especially for these codes and laws which are going to cover so many people. Once we have that, maybe we will be at a stage better to accept whatever changes the UCC is going to bring. And I'm not on the point of the second question, about the majority, minority, etc., etc. Of course, the majority, certain practices might also change. The entire definition of majority and minority is so lopsided. As I said, there might be minorities within the majority, and those nuances have to be first recognized before having or even, dreaming of something more, something so universal as a UCC.
Right. Okay. So we'll move on from that, and I think the points are duly noted. But again, then this question it is open to both Anurag sir and Niharika ma'am, and then we'll also get Sukhjinder sir to bring himself in on this constant point of we not being at this stage, we not being ready. And my question to you is, will we ever be ready for any sort of law? Because the law, if not implemented like this, how else do you want it to be implemented? And secondly, I'm glad that you brought in the public consultation point. Initially we were talking about why exactly the debate on UCC. I think that is why the panel discussion on UCC is taking place, because we want to have this perspective. We want to have this understanding of what exactly the public, believes in when we are talking about the Uniform Civil Code. Niharika ma'am, followed by Anurag sir.
Yeah, I would just
Okay.
like to
Okay.
quickly
Yeah,
pitch
go
in
ahead.
an
Yeah.
example for this first.
Yeah.
So yeah, like I completely agree with your will we ever be ready point, because initially we talked about the 2005 amendment in the Hindu rights, and how women got a share in the co-parsonary. So initially we were thinking that we're not right for it. It is the right way to go about it. We had big families. We didn't want our money to go away to our daughters, and we thought it was the right way apparently. But a change was brought in, and it was very well accepted by the society, and women all now there's women are happy, there's a glee of equality. So sometimes that this society has to be ready, and there is a time that there is a legal reform to be brought in, just to bring in a change in a society, just to change the mindset of the people.
Absolutely. Niharika ma'am, followed by Anurag sir.
Thank you. I think, what is coming out from everyone is there is certainly one uniformity where everyone agrees that we really don't know what we're talking about. I think Anurag sir put it so well to say that today there is nothing.
Yeah.
So we are all frankly shooting in the dark, and therefore everything we say should be taken with a pinch of salt, because we are all understanding UCC probably from our own limited social and political perspectives. And while I was the one who said that we should not look at it from a majority-minority point of view, but I completely understand what Kushank and Anurag sir are saying, because we don't operate in vacuum. The political and the social climate of the country is also inculcating a sense of fear and apprehension. That will our template for UCC be a majoritarian template? Will we only end up taking away the rights or what is perceived as rights in certain personal laws? Or will we really be able to bring about something what is called uniform? Like I said, that will the majority accept marriage as a contract? I sincerely doubt that. I think people will be up in arms if we said that marriage is not sacred and it's a contract, which is perfectly acceptable under Sharia law. It is a contract. So, so many thoughts in my head right now, after what Kushank said. One was the issue of codification. I agree with him that there has to be a more inclusive process. At the moment, of course, we only have a notification from Law Commission saying, give us your comments. If you ask me to give comments, I'll probably post them in a list of questions. Please give me a draft for me to comment on, right? So having said so, but where I do not agree is that it's not like there hasn't been codification before this. There hasn't been a uniform codification, but the legislature has already entered our personal law. There are statutes which are codified. So the only difference really that we're looking in codification is not whether the legislature can enact a law. That they can, they have all the power to. But how will they enact a law? And then, of course, how will it impact? So for me, the issue is really not whether there can be a codification or not. We are already codified, mostly all laws. And as far as customs are concerned, they're codified to the extent where customs are given recognition of law. Having said so, I think that becomes a secondary issue. It impacts the majority as well. For instance, this is something very wonderful that my colleague who's, we were having this discussion. You sparked a debate in my office. We haven't done any work in the last 2 days. So we were all discussing, and you know what you said about the Anand Marriage Act. How does that get impacted? Or how does the Hindu Marriage Act get, impacted by all of this? And someone said, okay, what? Because we also have to keep in mind Article 25. There cannot be a discussion on UCC without Article 25 being discussed. So someone said, but I have a right to practice my religion. And how I understand it, it means I have a right to get married as per my own personal law. So what happens? How can then UCC, without infringing Article 25, be enacted? How can there be a uniformity if you're going to take away my right to get married as per either Anand Marriage Act, Hindu Marriage Act, or the Sharia law, whatever it may be? To which someone said, maybe then you can get married how you know what you're saying. And this is again all shooting in the dark. You get married as per your religious cultures and rituals and customs. But then the government will say that you get registered under one particular, what may be called, let's say, an Indian Marriage Act. And then the rights and duties will flow from there. So it's extremely controversial, because then the next question we asked is, then what happens to the child that's born out of this wedlock? Is he governed by the UCC? Do his rights flow from there? Or will he be governed by what is going to flow from my personal law? Which begs the question of, am I competent of choosing for my unborn child? So it is extremely complicated. I think what is required is what Kushank said, a very inclusive process of consultation. And it cannot definitely be done before the next election. That should not be an agenda for bringing about UCC, because the apprehension and the fears will not be taken care of. You have to sometimes not only come across as doing what is good for majority and minority, but here, and by the way, the example I give could affect Hindus as well, who are in majority. Numerical, and here I'm majority minority purely on numerical strength of numbers. So it is so complicated, and such nuanced debates will come up from this. We haven't yet addressed Article 25. You know what Behel sir said, he practices Sikhism. I am not an actively religious person, but maybe he can pitch in. One is UCC operating just in my personal field, in my personal law. Now, carrying a kirpan is constitutionally protected under Article 25. But does that mean when UCC comes in, are we going to take away that protection and say that you will be governed by the Arms and Ammunition Act and therefore take a license for your kirpan? What happens to that? And if we don't do that, is it then discriminating and not applying UCC equally to all? Are we pandering to religious communities? So for me, there are just too many questions to ask right now. And the more I talk about this, the more questions come to my mind. I don't know, maybe I don't think they can take away the protection given under Article 25 to us, but I think Anurag sir may have something interesting to say on this.
Yeah, definitely. Before we just jump on to Anurag sir, I think Article 25, I am glad there are so many questions on board, and we'll try and provide answers also, because we have in some of it, which is, I think, brilliantly discussed. Whether you look at even the Nagaland Tribal Council, right, under Article 371A of the Indian Constitution, which guarantees that no act of parliament will apply to state in matters relating to religious or social practices. You can talk about the Nagaland Baptist Church Council as well, right? And then when they issued a statement about codifying the social, culture, and religious practice would negate the deep-rooted values and norms of the people. But I think I'll have to start making arguments as to why there cannot be two laws that govern the nation, because too many laws and too many problems. Anurag sir, your quick comment on this, and then we'll try and justify as to why exactly the debate on UCC.
See, fundamentally, please remember, all of us, that, and this is something which I have been quoting since my old, school debating days. This is my favorite line, that even roads to hell are made with good intentions. Please remember that. Now, no one is a BJP or anti-BJP or pro-BJP person, particularly when we speak as lawyers, we speak as legal practitioners. And we have a responsibility in the society, wherever we speak. When you talk about uniformity or a commonly driven law to be enacted in terms of uniform civil code, I think Article 25 becomes very, very much relevant. And there I would like to add on that I think Niharika must be aware of this, perhaps Behel sir also must be aware of this, that we are revisiting the Shirur Math case in that Sabrimala temple. 13 judges will sit down and then they'll visit this whole gamut of religious practices, personal laws, etc., etc. So when you say that I will be sharing a legal future where you will have to uniformly practice in terms of law, but you don't share any ideas, you don't share any draft, you don't share any words, I will be certainly not just critical, but I will be doubting the intention of the government, because your ploy is really staring at us, at our face, that you are just eyeing 2024 elections, and I'll not be shying away from saying that. One. Number two, Article 25, there are so many little things which, just emerged. You have just yourselves said about Nagaland. Where does it go? The answer is, no one knows. Where does it go? And it is not that the minority is fearing, the majority is fearing. No. The extent of the interference of state in private space, that's the question, please understand, in the name of uniformity. And Kushank very validly, I think he endorsed what Justice Krishnamurari, perhaps after retiring, has said in an interview, that this whole consultation has to be, you can bring uniformity, there's no problem, but have an exhaustive consultation with the society. And sir and ladies over here, 150 crore people consulting for Uniform Civil Code, that will certainly take some time. So I guess for us, it's very important to introspect that if we are able to, think above our own parochial thoughts, think above our own narrow visions, then perhaps, we may be able to see the light which the government is trying to throw at us. Till then, I will be doubting the intention of the government for sure.
Right. So Mr. Anurag feels strongly about doubting the intention of the government, and we'll bring in Mr. Sukhjinder here. But Ananya, even you can chime in after this. This idea of about separation of public and personal spheres, I think UCC, what the government is trying to do, or at least what the government states, is that they primarily concern itself with matters that have a public and legal dimension as well, right? When you talk about marriages and you talk about things that need reform, like something like a co-parental right can also be considered something to be in a personal space. But at the same time, you need to give that right to women. When you're talking about Article 25, let's not forget the Golden Triangle, Article 14, 19, and 21. Whether it's right to life, right to equality. So where is this contradiction inherently based in? Also, I'm glad that you brought out a judgment, sir, because there are a lot of judgments. In fact, why are we looking at only from the perspective of BJP or Congress or any other political party? Look at Sarla Mudgal, for example. There are a lot of judgments in favor of the Uniform Civil Code, wherein the court is constantly asked and time and again reiterated that we need this discussion, we need this, sort of collaboration. In fact, Justice Deepak Gupta, if I remember, in 2010, remarked on the lack of progress towards establishing a UCC, despite the court's previous urging in cases like Mohammad Ahmed Khan versus Shah Bano, or whether it was Sarla Mudgal, like I stated. So, is it not really just, it's not really is it just the BJP thing, or is it just a political issue? What about the judiciary, for example? What about the Supreme Court, which has been time and again constantly stating that, maybe it is time that we move towards the Uniform Civil Code. We'll take quick comments from Sukhjinder sir, if you're here, before before you can share the bios. Sukhjinder sir, you can please come in before we go on to Kushank again, followed by the discussion to continue. Yes, sir.
Earlier I said what I said. I would say that undoubtedly consultations would take time, but someday we have to start, either in 2024 or 2030 or 2050 is not the question. The question is, one day we have to think over it. As I earlier said, that the constitution way back, we have been mentioned that the reservation would be given for a particular period. But after 75 years, again, where we started after independence, we are there. There should be some time limit for doing the improvement. The improvement should have been done, must be done, I would say, keeping in view Article 25, 14, 16, 21, everything is correct. But one day we have to do something. It is not question of interference of personal laws. It is question that after consultation, after taking confidence of all, we can't keep happy everyone. When you force anything in your family also, there is some kind of opposition in your family also. We are a family. As a country, we are a family. We have to, as my dear just mentioned about the farming laws, I fully agree with him, because the people were not made aware what is the benefit going to be the farmers. We just oppose for the sake of opposition, without realizing the government should advertise, the government should inform everyone what is the pros and cons of these amendments, what is the benefit of the uniformity. And yes, of course, there are certain kind of harmed, or not harmed exactly, but some kind of opposition or some kind of interference is there.
Absolutely.
We can try to improve that. We can find out a via medium. Supposing, as Madam Niharika mentioned about taking the Kirpan is there, whether it would be followed by the Sikh Act or it would be followed by the Arms Act. Earlier, if Madam recollects, in 1982, when Simranjit Singh Maan was elected a member of parliament, he brought the Kirpan for about 4 foot along with to the parliament. They stopped it. Yes, now it is recognized that 6-inch Kirpan you can carry anywhere in the country. It is not required. So initially, there were a lot of opposition from the Sikh community, but later on they realized this ultimately is a symbolic one. So similarly, things which are very hard, supposing 4 marriages in the practice is allowed in as per the Muslim law, we can think over it. We can persuade them. It now the society is improved, the population, keeping in the totality of the effects, something is required to be done.
Absolutely. I think, sir, you're raising a very valid point, and I'll talk about Goa also, because we've been asking constant examples as to how we're going to deal about this issue, because I think couple of questions were raised by Niharika ma'am as well. And Anya, you had a question, so we'll move on with that, and then I'll put in the Goa model, for example. Yeah.
Yeah. I really appreciate the points put in forward by Mr. Sukhjinder sir. But from all that he said, I could just, one question really intrigued me, and I would like our panelists to answer that. It has been repeatedly pointed out that there is no draft on the table, and we should, the government should take in our comments, we should deliberate on it. But a really important question has been put forward by Advocate Sukhjinder Singh, that how much time will it take? Like, we cannot go on deliberating for long enough, and we cannot just be discussing about it. There is an urgent need for a law, and it has been long enough. Long time has been given to deliberate upon it, discuss upon it. There is need for action now.
And then, to be fair with you, so far as undoubtedly every government, they have certain agendas to be done, not to be done. Yes, I agree with Anurag sir when it is brought at a particular time, because the elections are due in 2024. Maybe their political agenda is there. I don't say not that. It may be, because all governments do it. But still, I would say that maybe after elections, but we have to do it sometime. We have to sit over and think over it. We have to do something. It is not only the Uniform Civil Code about these personal laws. It is required for other laws also, which we have kept open. I don't know when the government will woke up for these. There are a lot of things to be done, required to be done under the Constitution itself.
Yeah, absolutely. I think where there is a law, there are two views and there are problems as well. But exactly.
No, sorry, I just, Nihshank, pitch in, because this is very interesting. What Ananya said, that, and what Behel sir is saying, that at some point it has to be done. It is a directive principle. It is one of the aims of the Constitution. So in fact, way back, and this will also show why it's not a BJP, Congress, any kind of political agenda, because when this was being debated, one big suggestion that came forward was that please don't make it a directive principle in perpetuity. Put it as a 5 to 10 year gap. This is the first health minister of, I'm forgetting her name, it can come to me. This was the first health minister of our country who had written down and penned down a letter to the Constituent Assembly to say that please put a 5 to 10 year gap. Otherwise, what will happen is what is happening now. Any future government would either use this as an agenda or oppose this as an agenda. So today, I think it's definitely political. I'm not going to shy away from saying it is political. Good, bad, ugly. I mean, what may come out of it is it's going to be, I hope it's not unfortunate. And I hope we remember that there are certain minority committees that have to be protected. And, you know, when somebody was saying something about the majority, now under the Hindu personal laws, a father is seen as the natural guardian for the first 5 years. It's not the mother. Now, are we going to make this gender neutral? I'm not saying father ko hata ke mother ko natural guardian bana do. I'm saying UCC will then also bring in questions of, are we making gender neutral norms?
Absolutely.
So, yeah,
Absolutely.
I mean,
Yeah,
just
what I get from this is I think we don't have to even wait till the consultation phase. This is the consultation phase, and I'll directly go on to you, Kushank. The idea here being India is ready for UCC. Is this panel? Please take it forward.
But you know, I would like to go 2 steps back, and I know I'm in some way contradicting what I said when I said that we are not ready for the UCC, etc., etc., or we need some more.
You have evolved.
That is the beauty of this panel. So, you know, the deliberation requires more inclusive consultation, etc., etc. But one fundamental question that I have, and that is that, do we really need the UCC? Do we really need the UCC? That ultimately, as things stand, we have a very elaborate constitution of India. And the favorite part, especially for all of us, at least law people, is the entire chapter on fundamental rights. Whatever is against fundamental rights is inherently wrong. It should be struck down or whatever. I mean, at least you have a case to go to the Supreme Court, and then the Supreme Court, High Court can say something. So when all these protections are there, then do we really need the UCC? So there are 2 parts to it. One part is that we really don't need the UCC because the Constitution provides an effective framework. When we have a UCC, what is the need for doing all this exercise, bringing all these communities onto one page? See, we can't look at UCC as a panacea for all problems in this country, and as though, that will bring all, solutions to all problems. We can go in for incremental change across religions. But there's a contra view, and that is we need the UCC. And I'll tell you why we need the UCC. And that is because if we look for incremental individual changes in individual religions, maybe that change, we are finding it hard to bring about. The Goa example has been given, but I was reading somewhere where the civil code is there in Goa, but I was reading somewhere where I believe that if there is no child after marriage, then the husband has the right to remarry or something of that sort, which exists in Goa. Now, the changes, modifications in those specific things, or what Niharika ma'am said about, the natural guardian, etc., the mother should also have the right to it. Those individual changes probably is difficult. Maybe if we do it under the garb of UCC, so a lot of these problems which are there in these religions can on their own, they should be diluted. Okay. But
Right.
again, it really begs the question that do we need the UCC?
Right. So from going to, we'll just go on to you, Mr. Sanjay. We have a representative of the Bharati section Mandal as well with us. Mr. Sanjay is going to speak on the, on why UCC is important. So I'm glad he's come in at the right time, because the question has been raised as to whether we need UCC or not. And I'll just, I'll just propose a model before we move to you, Mr. Sanjay, and then we can comment on this model. Like, let's take Goa, for example, right? It represents a model of legal uniformity, and obviously it has its own problems, and obviously I want you guys to cover it as well. But despite not covering all areas, an ideal UCC, as we are trying to frame in this panel, it treats all religions equally, tries to uphold certain specific rights. For example, on December 2022, 2016, a key reform replaced parts of the Portuguese Civil Code with the Goa Succession Special Notaries and Inventory Proceedings Act, right, which was back in 2012. And it did it mainly in matters of family assets. Whether it is the marital property laws in Goa, which require equal ownership of assets acquired before or after marriage, or whether it is allowing each spouse to claim half in case of divorce. And also whether, you talk about pre-nuptial agreements, that is also there. Like it's been incorporated, wherein half the property must also legally pass on to the heirs, even if it is self-acquired properties, right? Resembling the co-parcenary concept that we talked about in the Hindu law. And the UCC also bans polygamy for Muslim men for marriages registered in Goa. I think Kushank brings in a really important point that, you need that one law, it's that one strike, is that one bowler which will bowl in the right 6 Yorkers, and you get all their 6 deadly batsmen out, which is the inherent difficulties or discriminations that are there in different kinds of religion. In India, you speak 398 languages, which out of which 11 have become extinct. I mean, we're dealing with a diverse country. You need that one law to, strike all the indifferences. Mr. Sanjay, please. Before that, Nana, did you, I think you wanted to say something? If you want to, yeah.
Yeah, so, quickly summarizing the points about why do we need UCC. So I think it would really help us in social cohesion and national integration as well, because a UCC fosters a sense of national unity by providing a common legal framework that, applies, I would say, uniformly to all citizens, irrespective of the religious backgrounds. And the cohesion approach strengthens social harmony. And we have seen examples of it before. And, it also promotes national integration as it reflects the principles of secularism in the country.
Right. Mr. Sanjay, you can come in here. You have 2 things on board: the Goa model for UCC and the social cohesion aspect, and then we'll move on to Niharika ma'am, followed by Anurag sir and Kushank back again. Yeah.
अच्छा, मैं हिंदी में ही बोलूंगा, जो है दिक्कत नहीं होगी ना किसी को?
नहीं, बिल्कुल, हम तो एक्सपेक्ट कर रहे थे कि एक हिंदी स्पीकर भी आ जाए. मैंने स्टार्टिंग में इंट्रोड्यूस करा था कि हिंदी में भी हम सुनेंगे लोग.
ऐसा है, मैं इस यूसीसी पे ऐतिहासिक दृष्टिकोण से बात करूंगा. ऐतिहासिक दृष्टिकोण क्या है कि यह यूसीसी जो है, यह एक देश विभाजक जो है कानून के रूप में भारत में आया. जो मुसलमान 1937 के पहले भारतीय हिंदू कानून से चल रहे थे, वो अचानक 1937 में इस कानून आने के बाद से 1940 का लाहौर जो घोषणा पत्र है पाकिस्तान बनने का, क्योंकि यह मुसलमानों को एक प्लेटफॉर्म पे लाकर खड़ा कर दिया और उनका जो अस्तित्व था वो एकदम सेपरेट हो गया हिंदुओं से, क्योंकि वो भारतीय हिंदू कानून के माध्यम से संचालित होते थे. आप वेस्ट प्रोविंस का देख लीजिए, पंजाब वेस्ट प्रोविंस को देख लीजिए, केरल का देख लीजिए, भारत यहाँ तक अभी कूच बिहार में 1980 तक जो है कूच बिहार जो मुस्लिम शासक प्रदेश था उसका भी बंटवारा जो है 1980 में भारतीय हिंदू कानून के तहत हुआ. लेकिन यह कानून इसलिए था कि जब कुछ मुसलमान एलाइट जो अंग्रेजों के साथ मिले हुए थे, वो जब भारत का विभाजन नहीं कर पा रहे थे, उस समय जो है ये कानून लाकर एक सेपरेट दीवार खड़ा कर दिया गया. और इससे क्या हुआ कि एक अलग एंटिटी खड़ा हो जाने के बाद जो पाकिस्तान का प्रस्ताव आया, तो क्या ऐसा हो सकता है क्या कि हम ऐसे किसी ऐतिहासिक भूल को निरंतर जारी रखें जो हमारे पीछे हुआ और एक देश का विभाजन हुआ, फिर दूसरा देश का विभाजन करने के लिए तैयार हो?
Absolutely. I think okay, he is not like thank you so much. I think I'll go back to Niharika ma'am. He's making a very relevant comment to put it fairly. He's talking about the colonial implications, ma'am. And like let's not ignore it, because this has been discussed in the parliament. There are actual parliament notes about what speakers have said, and I think this is very important when we're trying to understand the perspective of social cohesion as well. And Anurag sir, you can also pitch in here. Ma'am, I propose the Goa model, right? You see your problems with it as well. What do you think if we were to include it in a national agenda? Let's take the state model, for example, and then try and see it and compare it with the national agenda. Is that serving us right, or are there inherent difficulties in it?
See, there will always be inherent difficulties whenever, I don't remember who's the panelist who said this, probably Mr. Bell, who said that anytime you bring about a new law, there will be inherent difficulties which can be ironed out subsequently. Now, whether that may be by way of a challenge before the Supreme Court, or that may be in terms of its implementations. But just to comment also on the colonial aspect of this, or what we are presuming is, I'm not quite sure which side is the question leaning on. Are you saying that UCC is a colonial concept, or are you saying that it was prevented because of colonialism? Sorry, a question was not clear to me.
No, so basically, he's talking about the colonial implications as to how UCC has been framed with that mindset. He said, is this UCC an outdated law? Is something that, you know, is this concept? Yeah, okay.
Absolutely not. I don't think this was ever imposed on us by the Britishers or the colonialists. And it is definitely not a Western concept. When the World War I ended, all of Eastern Europe included protection of rights in their constitution, protection to minorities, all of them, Austria, Czechoslovakia, back then, how it was then. So it is not as if this is unique to us protecting the minorities. Eastern Europe did it way back when they codified their constitutions. And it cannot, to my mind, it cannot be a colonial influence because we had representatives of different minorities when this was being debated. And in fact, there was a big push for implementing it for the reasons that Ananya pointed out. There was a school of thought that said that India could not be a nation, or the nationhood was delayed because we were divided by our personal laws. Ultimately, of course, probably it is the implementation of it that has delayed UCC because we're a diverse country. But there was a big school of thought and a big section of the Constituent Assembly that spoke in Ananya's words that it brings about the concept of nationhood, a social cohesion, unity, harmony, right or wrong. So, to my mind, it is not a colonial concept at all.
All right, ma'am, but what about the Goa model? Sir, even you can take this and I'd like Sukhjinder sir to come in on as well. Take the Goa model, for example. Try implementing it nationwide. What are the problems? What do you feel is the issue substantively, if we could point it out? And Anurag sir, you can take this up, followed by Sukhjinder sir, and then we'll go back to Kushank.
See, again, please understand, we are living in 2023. And as human beings, we fail to learn from history. Please read history, whatever book you want, Will Durant, X, Y, Z, whatever. We don't learn from history. And when individually we speak, our parents keeps on coaxing, ye mat karo, isko is tarike se karo, usko waise mat karo. But we all have been rebellion throughout the life, if we look at our lives individually. Now, same is the case in the realm of law. Law develops only when the judge is the rebellion or the legislature which is there, that is the rebellion. Now I am going contra. I have also evolved in this 1.5 hours. Now, if the parliament wants the society to think, it will certainly throw a dice, which is Uniform Civil Code. It has triggered all the young minds in the country. We are having such symposiums, such seminars online every day. Here you are seeing so many people contributing valuably to this Uniform Civil Code thing, that whether this will be a success, this will be a failure, can this be done, can this not be done. Your Goa model, Nagaland model, Tripura model, Jharkhand model, Kashmir model, Chennai model, those temples, right to visit temple, females going inside temples, not going in the temples, all these things. But please remember, which Mr. Upadhyay said, I don't wish to go into the historical, corroborative things about the colonial hangover. But the fact is, we all have that hangover. We like eating cakes. We like eating coffee. So what's the harm in having the, law or some legacy which is coming from there? You may not like it, but that is there. We are wearing this shirt. Whatever we are having, it's all colonial hangover. So, and I don't have any problem with that. But what we need to understand, that as a society, you also have to be very conscious of this aspect, that every moment, every second, you need to evolve. If today the women have got co-parcenary rights, it is because the parliament thought that now it's the right time where the due must be given, right? Our mothers have worked hard, very hard. They have been working inside homes, outside homes. without any salary, without any rights in the property. And we as lawyers every day, I believe most of the lawyers over here and the people who are here out from other realms of the society would agree that ultimately any domestic dispute which is between the brothers, family, or any kind of genre, that boils down to the division in the property shares, to division in the money shares, etc. All these small nitty-gritties, right? And when we talk about uniform civil code, we are talking about defining how the finance will be imparted, how the social right will be imparted. Tomorrow, suppose I am a Hindu, I die, and if I don't have a daughter right now, but suppose I have a daughter tomorrow, adopted daughter. Now, will my son will give me, will do the last rites for me, or my daughter will do it? Then the conflict will come with the Hindu scriptures and all that. So there are so many tiny things, and all these things can be answered only if the legislation which has to be brought in, the draft is thrown at the public. You can't just ask people to be debating in air. That's not the thing which we could do or you could do. No, we can't do that unless this parliament, comes out clean in black and white, which it has not, unfortunately.
All right. So I think we should reframe the agenda of this panel discussion to UCC or evolution, because I've seen speakers go on from point one to point B, and like Anurag sir is constantly saying, I what. But okay, help me understand this, because I've proposed the Goa model, and I think this will be our final point of discussion, after which I'll take your concluding remarks, and we'll have a question and answer session, after which we'll close the session. Okay, and Ananya can also come in here. Help me understand this better with respect to anyone who's been, talking about consultation with respect to the UCC. When the farm bills were supposed to come in, we were talking about how consultation is important. And now, we then discussed it a lot about public engagement and all of that. What if we were to put a sunset clause? For example, for viewers who were not aware about what a sunset clause is, like the name suggests, a sunset clause has to be uniformly reviewed. And once, if it is not reviewed, then it elapses in thin air. So let's say you have a law for uniform civil code that is implemented by the government. A draft is given out. The law takes into consideration all the different aspects that we are trying to take into consideration. And then you put a sunset clause. Sunset clause being that you uniformly try to review it after 5 years, 2 years or whatever, or annually. And if it does not stand the test of time, if it does not stand the test of ground, then the parliament votes on it to dissolve it. How does that sound to our speakers here? Mr. Sanjay, you wanted to make a remark, and then we'll quickly take comments by Sukhjinder sir, Kushank, and then Nihar Kama. After which we'll look for closing comments. Ananya, please you.
Yeah, yes, as rightly pointed out by Anurag sir, we have evolved, but so after your speech, I just wanted to, pose in one question to you. So, I researched a bit on triple talaq and how the Shaira Bano judgment has turned out. Is it beneficial for Muslim ladies or not? So the judgment has basically banned talaq-e-biddat, and it has said that you cannot divorce your wife by saying talaq thrice at a particular point, but you can still say it throughout a period of 30 days. That is through talaq-e-ihsan and hasan. So, I feel that the prerogative and the picture that was portrayed to us by the media agencies was that triple talaq is now banned. You can no longer divorce your wife by saying the talaq word thrice. So there's a very good element of appeasement politics here. I'm not blaming the BJP government for it. The politics has, even they are into some business, and they are here to benefit out of it in some or the other way. But even Congress has done it time and again. But are these political parties really looking after us? And should we give them the power to really evolve the countries, decide the laws for us, and we should really rely on them so much?
I think she's questioning the entire political system that which we end up doing anyways all the time. But yes, Sukhjinder sir, we'll take your quick remark on this, followed by sorry, I'm so sorry, Sanjay sir, you can just come in after Sukhjinder sir is done, and then we'll take their concluding remarks.
As you just mentioned, there is no harm by setting the sunset clause, because whatever reaction is to be done, to every action there is equal and opposite reaction is there. If some clauses are, I would say that instead of forcing or thirsting upon the religions or the society, let first consultation should be made, and thereafter, after obtaining their views, it should be incorporated in the court, and subsequently it should be implemented for a particular period. And if it is going to make some kind of loss to the personal laws of the individuals, only then it should be taken back. Otherwise, I'm sure it will be accepted with the passage of time. If it is implemented for 2 years, certainly it is going to be accepted. There is nothing in the Nandakaj Act. What has happened? Because whenever we bring in certain new laws, instead of the positive advertisement, the negativity is there that the government is bringing. Because most of the people are anti-incumbency. Various political factors are there. So instead of projecting the positiveness and the ideas brought by the government, we first attack on the negativity, that we are going to divide it, we are going to do this, because we don't tolerate the government is improving and trying to improve the nation or the society. So there is no harm in doing it. Let it be in a phased manner. Let it be after consultation, deliberations of the religious leaders, of the personal, everyone. They should be taken into confidence, then it should be implemented.
Right. Anurag sir, your concluding remark on this. Sunset clause, in and out or offset? Sanjay sir, we'll just come to you.
I think we should not have an experimental law, particularly when it comes to the domain of, personal religious property, all these internal rights of an individual. I'm not on that. One. Number two, if this government or if any government, I'm not talking about X, Y, Z, whatever, Congress, BJP, Janata Dal, whatever, if they are really in for equality and uniformity, the first thing which they should hit at is the equal representation of women in the parliament. And when I say parliament, I mean from top to bottom, till Panchayati Raj down below. Number two. Number three, if the government is really sincere and serious, please have a very, very regular, clear, transparent audit of your election funds before throwing this uniformity thing at us citizens. I don't want that. And fourth, as a lawyer, you should not be talking in air. You are a government. We seek some sense of responsibility from you. So once you are throwing any subject to debate at public at large, particularly when India as a country of 150 crore, with so much of diversity, there should be something concrete. You must not talk in air.
Right, absolutely. Thank you so much for joining us
Thank
here
you,
as well.
everyone. Thank you, everyone.
I'm extremely glad that your concluding remarks are very well pointed as well. And we'll move on to Sanjay sir. And just to tell everyone who's joined in, I know it says 10 p.m. to 10 a.m. to 2 p.m. does not mean that it has to go on for 4 hours. It's not a movie or things like that. We'll just keep it short and crisp. I'm glad the pointers are being very straight and we're trying to address every fundamental issue. And let's do it. Let's keep it crisp and concise. Sanjay sir, followed by Niharika ma'am. We'll take your comments on the sunset clause and your conclusive remarks, followed by Kushank. And if there are any questions, please, I would request the speakers to wait for it and answer it, and then we'll end the panel for today. Please, Sanjay sir, go on.
ऐसा है निशंक जो है कि आज के भारत में भी अभी भी भारतीय सभ्यता में जो पासमानदा मुसलमान है, जो 85% भारत का प्रतिनिधित्व करते हैं मुसलमानों का, और जो अशराफ मुसलमान है, तो इसमें 85% पासमानदा मुसलमानों में अभी भी 90% मुसलमानों का जो घर गृहस्थी है, जो उनका लॉ है, वो अभी भी वो हिंदू लॉ के हिसाब से चलता है। ये बड़ी भूल हो रही है। ये डाटा गलत दिया जा रहा है कम्युनिस्टों द्वारा और कुछ जो एलाइट मुसलमानों द्वारा जो है कि जो है वो ये करने के बाद जो है इस प्रकार की स्थिति पैदा हो जाएगी, क्योंकि डिवीजन, देखिए जब तक डिवीजन बना रहेगा समाज में, तब तक जो है जो देश के बाहर वाले जो लोग हैं वो उसका एडवांटेज उठाते रहेंगे। इसलिए मैं कहता हूं कि आप सर्वे कराइए पासमानदा मुसलमानों का। पासमानदा मुसलमान आज भी भारतीय हिंदू पद्धति से ही अपने घर को चलाते हैं। उनके घर में भी आज भी लोग जो है धोती, उनकी स्त्रियां धोती पहनती हैं, सिंदूर लगाती हैं, और जो है उनके घर में भी लोग उसी प्रकार के रीति रिवाज अपनाते हैं, एक ही शादी करते हैं। तो इस प्रकार से भ्रम न फैलाया जाए। इसलिए मैं कहता हूं कि देखिए और जो गोवा का लॉ है कॉमन सिविल कोड, उसमें वो क्रिश्चियन लॉ से गवर्न होता है। उसमें जो है ये इस प्रकार का लॉ नहीं है जो यूनियन जो है यूसीसी की हम बात कर रहे हैं। उसमें क्रिश्चियनों का जो 2 साल का पीरियड है, उसी पीरियड के हिसाब से उसमें होता है। और मुसलमानों का जो लॉ है, अगर आपको लागू ही करना है तो पॉपुलेशन बढ़ाने के लिए क्यों लागू करें भाई? तो हम फतावा आलमगीरी जो औरंगजेब ने बनवाया था उसी के हिसाब से हम लागू कर देना, जो है सारे लॉ उसी हिसाब से लागू कर दे। वो तो कई लोगों को लेकर बनाया था फतावा आलम।
जी समझे आपकी बात। आई अंडरस्टैंड एंड आई एम ग्लैड कोई हिंदी में भी बोल रहा है बिकॉज मजा आ रहा है। एंड इज देयर अ लॉट ऑफ आई सी अ लॉट ऑफ स्पार्क all of a sudden on the panel, but we'll get to that. I mean, what he's basically trying to say, वो क्या बोलना चाह रहे हैं कि there are certain aspects, and it is absolutely true whether he's talking about a particular sect, कुछ it does not matter whether the religion is different. There are certain sects that are governed or they can choose to be governed by what kind of beliefs they hold in, right? We're talking about the personal spaces, even though a broader Muslim law might be applicable to them. So I mean, what narrative and what perspective do we take into consideration there? That's a valid point if I were to contend it. I mean, apart from everything else. But Niharika ma'am, followed by Kushank and Sukhjinder sir, on the sunset clause, please. Can we have the sunset clause? Like Anurag sir is saying that you cannot have an experimental law, but why are we not ready to experiment? What is the hesitation? If you're planning to bring it on board, let's do it for an year. If it does not work out, I mean, obviously we're talking about taking everyone together, we're talking about the consultation, and then after that you do this sunset clause thing, and if it does not work out, you remove the bill. What's the issue, ma'am?
Yes, thank you. But can I also ask a question to Sanjay ji?
Yes, absolutely. Feel free.
So I want to understand, Sanjay ji, आपके हिसाब से यूनिफॉर्म सिविल कोड का, क्योंकि आपने कहा कि जो मुसलमान घर गृहस्थी अभी चल रही है वो एक हिंदू कस्टम्स के हिसाब से ही काफी चल रही है। मुझे नहीं पता इस पे आपका डेटा कहाँ से आ रहा है, पर आपके हिसाब से ये जो यूनिफॉर्म सिविल कोड आएगा, ये क्या हिंदू जो लॉज हैं उसके उस पे होगा कि सारे जो रिलीजन है, क्रिश्चियन मुसलमान, सब लोग हिंदू लॉ फॉलो करें?
नहीं, हिंदू लॉ नहीं है। राष्ट्र का एक सिद्धांत होता है, प्रत्येक विश्व के प्रत्येक देशों में संस्कृत के हिसाब से संस्कृत सापेक्ष संविधान बनाए जाते हैं। संस्कृत सापेक्ष पूरे विश्व का नियम है। और मैं ये बोलता हूं कि पूरे विश्व का सार्वभौम सिद्धांत है कि सत्य और अहिंसा, यह 2 विषय जो है हर संविधान के मूल में है। लेकिन यहाँ स्त्रियों के साथ जिस प्रकार की अहिंसा हो रही है, उनका मुता निकाह हो रहा है, उनका हलाला हो रहा है, उनका जो है जब होता है तो उनको डाइवोर्स दे दिया जा रहा है, यह जो अधिकार है, हम कहते हैं कि भाई दत्तक पुत्र लेने का जो बाध्यकारी नियम था, जो दत्तक पुत्र नहीं लिया जा सकता मुसलमानों में, वह भी तो यूसीसी में, वह भी तो शरिया लॉ में नहीं लाया गया। इसके बाद जो खेती वाली जमीन थी उसको भी शरिया लॉ में नहीं लाया गया। तो यह एक प्रकार का विभाजन करने का एक कानून था, भारत में लाया गया था। और यह विभाजन करने वाला कानून अब भारत में नहीं रहना चाहिए। यह विभाजन करने वाला कानून है। ऐसा तो नहीं है कि उनको गाड़ने की अनुमति नहीं दी जाएगी, या उनको जो है बोला जाएगा कि आप मुसलमान हैं, आपको जलाया जाएगा जिस तरह चीन कर रहा है। तो ऐसा तो नहीं है। उनको मस्जिद में जाने से रोका जाएगा। अरे भाई, आप जहाँ जाते हैं वहां जाए, जो करना है करें। लेकिन शादी विवाह जो है और सारे जो नियम है, वो तो एक इस्लामिक देश नहीं मानते इसको। आपको बता दें, संविधान सभा में बहस हो रही थी उस समय, खोजा इस्माइल जो है समाज, जो जिसमें आपके ये हुआ था, जो है जिन्ना जिस समाज का था, खोजा इस्माइल समाज, और ये लोग कितने लोग मुसलमान जो थे वो इस लॉ को नहीं मान रहे थे। 1855 में शरिया लॉ मद्रास रेसिडेंसी ने डिसअलाउ कर दिया था। तो
संजय जी, एक बात बताइए, तो उस हिसाब से, आई एम सॉरी, आई डोंट नो इफ यू गाइस विल परमिट अ फॉलो अप।
No, please go on, it's fine.
संजय जी, जो हिंदू लॉ है उसके हिसाब से जो मेरा बेटा है जो अभी 1 साल का है, ये क्वेश्चन मैं रिपीट कर रही हूँ बिकॉज पैनलिस्ट ने ऑलरेडी कंसिडर किया है, पर आपने इस पे शायद वेट नहीं किया। मेरा बच्चा 1 साल का है अभी, उसका जो नेचुरल गार्डियन है, क्योंकि आपको विमेन राइट्स का बहुत चिंता है कि मुसलमानों में विमेन के राइट्स नहीं दिए जा रहे हैं, तो ऐसे तो हिंदू लॉ में भी बहुत चीजें हैं जो मेरे हस्बैंड को, मतलब बच्चे के फादर को माना जाता है कि अगर कल को हम में कोई झगड़ा होता है तो उसका पहला राइट है, पहला राइट मेरा नहीं है, हालांकि मैं उसकी माँ हूँ, तो मेरे राइट्स भी लिए जाएंगे ना।
नहीं, अगर हिंदू लॉ प्रॉपर देखिए, यह जो लॉ है, यह जो लॉ बनाया गया, यह इंडियन एडमिनिस्ट्रेटिव एक्ट 1935 और इंडियन इंडिपेंडेंस 1946 के माध्यम से बनाया गया। मूलतः भारत पे 1000 शासन करने के लिए अंग्रेजों ने इस लॉ को बनाया था। ये एंग्लो क्रिश्चियन लॉ है, भारतीय लॉ नहीं है। हाँ, और इसके बाद जो है इसमें आपके 1972 के संविधान सब
संजय जी, इफ आई कैन कम इन हियर, बिकॉज मेरे को आपकी बात समझ आ रही है, एंड आई थिंक वो नो, अगर डिफरेंट पर्सपेक्टिव से उसको देखें तो वो कंप्लीटली डिफरेंट साउंड।
मैं एक बात इनको बता देता हूँ निहारिका जी
बिल्कुल।
को, कि जो हमारे शास्त्रों में लिखा गया है, कि हमारे शास्त्रों में जिस हिसाब से लिखा गया है उस हिसाब से अगर देखा जाए कि ये 10 गुरु से बड़ा होता है पिता, हाँ, और 10 पिता के तुलना में जो है माँ का महत्व अधिक होता है। तो आप माँ के महत्व को कम नहीं किया जा सकता। जो कि जो भी जननी का स्तोत्र है, माँ को ही माना जाता है। यत नारी पूजन, उसमें बोला भी गया है कि यत नारीस्तु पूजनते रमनते तत् देवता। यह जो है नारी का बहुत बड़ा अधिकार है। अगर पूरी तरह हिंदू लॉ को लागू कर दिया जाए तो भारत आज भी विश्व का राष्ट्र गुरु।
राइट। I get it. Take it.
हिंदू लॉ
Ma'am,
को लागू करना चाहिए।
if I can just come in, and then I think we'll take your comment very quickly.
Yes,
I think what he's speaking from is I think what he's speaking from is the perspective of that, when you talk about whether Bhagavad Gita, let's take for example, you talk about that ancient traditional scriptures, and I think a lot of us take pride in it irrespective of whatever religion we are coming from. So that entire concept of Hindutva is not Hindutva in the sense that we perceive it today, but that that everybody is a Hindu, like the the right-minded government says so, that everybody is Hindu in the sense that everybody can have their own beliefs and set of whatever they believe in, that can exist, and that is fine. I mean, and I think he's coming from that traditional mindset wherein he's trying to say that if you were to go back to the origins of our scriptures and whatever this is, like this, he feels is falsified, and it has been colonialized, and it has been something that has been reframed and defamed. Like that is not the original Hindu law to say so, but we don't exactly have evidence of what exactly the original Hindu law would say.
Follow-up question. When we talk about this, but polygamy up to 1955 was permitted in Hindus. So why did we not talk about UCC then, as opposed to just amending a personal act? Because when we talk about, when Mr. Sanjay ji जो मुसलमानों की जो उनकी women है उनकी protection बात कर रहे हैं, वो कह रहे हैं अब UCC आना चाहिए क्योंकि उनको protect करना है. It's very benevolent of us. But why did we not think of UCC, or why did this debate not get sparked when polygamy was permitted? We simply amended the Hindu Marriage Act. But anyway, I understand what is also falling from you. This debate is getting enlarged, and of course, many tempting questions have thrown up, and it would be endless. Maybe we would go beyond 2 p.m. But my concluding remarks, of course, were on your question of the sunset clause. Dialing back to that, I agree with Mr. Anurag here that I do not think a sunset clause would be advisable, because it would be if suppose after 2 years we find that this is what you said is not working, it would be, how do you unscramble an egg? Because in 2 years rights would have been created under a certain act. So I don't think you can then take away those rights, because it would create a completely chaotic and anarchic situation. You do not experiment with rights of people, especially when they're personal to you. So my crisp view on sunset clause is that no, we would be better off, I think, adopting what Kushank said is a longer consultative process. Maybe have, instead of the approach that the government has right now of inviting objections through the law commission, maybe we go back and have committees, which could, several subcommittees that look into the smaller issues where different religions and stakeholders and genders can give their inputs. I mean, so far we've had the occasion only to talk about religion and a little bit of Article 25, but we haven't spoken about how this is going to impact different genders and what is the definition of gender. But let me not open that debate. Maybe that's for your next talk show. But I'm not in favor of sunset clause at all. It would create a very chaotic situation. My concluding remark is that UCC would be a welcome evolution, but it has to be an evolution. It cannot be an override change and of rights and duties that have been governing us since now 1947 and 1950. So it has to be, like I said in the beginning, maybe in the form of amendments, small amendments, as opposed to one code, because we see the practical difficulties in implementing something like that in a country like ours without taking away from the people.
Right.
So of course,
Okay.
and everyone is going to conclude
Yeah.
by saying we get to see a draft.
Yes, ma'am, I have one clarification, I think, from his perspective, and then one quick follow-up also to your question on this sunset clause. Ma'am, one clarification, I think, from his perspective is that he's saying that even when you're talking about the polygamy that was allowed in you dating back to the 1955 Act, he's saying all that is not the Hindu law at all. He's saying the Hindu law is what is written in Bhagavad Gita, and you should like go back to those scriptures and texts, and then like, so that's a completely different point altogether. Like, that's not even related to the point at hand. And we'll come back to you, Mr. Sanjay, because we're taking just the concluding remarks. But let's move on to the sunset clause discussion, because this is a legal point. We understand that there is a larger consultation that is needed. I say you take that consultation period. Let's give ourselves 6 months, 1 year, whatever time we need. We give ourselves that consultation period. So the law is not being framed out in air. The law is not being framed in vacuum, to say so. When that happens, once the law is there, if you have the provision of the sunset clause, if anything at all goes wrong, we'll have the option to at least repeal or, do away with it. So like something is better than nothing kind of an approach is what we are trying to take. We're not denying the consultation. I am glad Kushank pointed that out. And, obviously we want to incorporate that consultation period. But still, why not incorporate the sunset clause after the consultation?
So when we talk of a sunset clause, there's something interesting that fell from you right now is one that we should have the option of repealing it, which we will always have.
Yeah.
We all have the option of repealing any law that we want. However, my fundamental problem with that is how does a sunset clause, I can understand how a sunset clause operates in a commercial sphere or maybe a civil sphere. How does it operate when if today there is a child that is born? Are we suggesting that the rights that govern the religion, the inheritance, the identity of that child, and are we going to then change it after 2 years? And is that child capable of saying after 2 years, this is not working for me? Then we have to wait full 18 years for him to attain majority and then say, sorry, this didn't work for me.
Right.
Yeah.
They hit the nail on the head.
Yeah,
Yes,
exactly. That was a very good loophole.
Yeah, absolutely. Thank you so much. Ma'am, do you have concluding remarks? I think, Sana, you raised your hand. Is there a question for Niharika, ma'am? Because then we'll move on to Kushank. Sana, are we audible to you? We have Dr. Yeah, Dr. Sana, go on. Yeah, please go on.
Yeah. So it's not a question exactly. Rather, I would put it in as a comment. I mean, I suppose being the only Muslim representative over here, I'm not taking it personally, but I would just like to pitch in over here, stating that even as Muslims, or even the leaders, the Muslim leaders, they themselves are not very religiously educated, I would say. Most of us, we use religion as a matter of our convenience. And that is the reason why so many disputes have erupted. Okay, so the Sharia law has its primary origin, or the original source of the Sharia law is the Quran. And Quran is a common principle or a common book for all the Muslims. So after that, whatever has been formed, the sects, the divisions, and the different laws pertaining to those different sectors, they are all man-made. And of course, now the laws which are going to be man-made are going to be disputed because one is going to agree, one party is not going to agree. So the problem over here is that before coming to the point of UCC, the point over here is each individual community, whether it's Muslim, Christian, or whatever, they have to first have a common consensus regarding to their own laws. They cannot use the laws as a matter of convenience. So the Muslim men cannot use polygamy as a matter of their convenience, because we speak about polygamy. Do we know further about polygamy? So the Muslim law, the Sharia, has specified laws on how you can actually perform polygamy. It's not like mujhe shadi karni hai, so I'm just going to go and marry for a woman because of my convenience. It's not like that. So people are, the laws, the Quranic laws, the Sharia laws have been very grossly misinterpreted, and mostly by our religious leaders. So they वो अलग अलग फतवा निकाल देते हैं, हम ये सेट को बिलोंग करते हैं, हम वो सेट को बिलोंग करते हैं, and then it's a whole chaotic situation. So the
Right.
first, the
Right, Sana.
uniformity has to be in the
Perfect.
individual minorities, and then we can proceed.
Okay,
to proceed.
okay. We get it. So that's a
Yeah,
very
thank you.
important point also. Ananya, I would like you to take on from here and then we pose it. But just before that, thank you so much for joining us, Niharika ma'am. It has been a pleasure to host you, and I hope you enjoyed this lively discussion. If there are no more questions for her, we'll let her go. And because we're going to, Acha, so I think Mr. Sanjay has a question for you before we can, Ananya, before you can summarize what.
Yeah. I'll just first quickly summarize Dr. Sana's point. I think she made a very valid argument, and rightly said that she's from the Muslim community here. So, she's raised a very valid point here that are we even clear about our own personal laws, before we go into and look at the bigger picture of whether we want a uniform civil code? Because yes, rightly pointed out, we are using the religious laws at our own convenience, and sometimes we are saying that your polygamy is the right way to go, and after sometimes like Niharika ma'am rightly pointed out, in 1955 it was repealed out of the Hindu laws as well. So we really need to introspect here and
Absolutely.
trying to see whether we are clear about our own personal laws at all.
Right. Have some sense of conformity about your own laws before you go into this broader picture. I see Mr. Santosh Kumar also is been referred to as user. He is the Secretary General for Havla Chamber of Commerce and Industry is also here. Ma'am, I think you won't be able to leave us so early. You have quick questions. So you followed by Sanjay sir, followed by Mr. Santosh, please. And Kushank, we're waiting to hear from you. We just let the this battle go on for a while and then we'll. Sanjay sir, please go on.
हाँ, मैं निहारिका जी को एक बात बतलाना चाह रहा था कि
Sanjay sir, we'll keep it as a question because
क्वेश्चन ऐसा है कि जो
बिल्कुल।
पॉलीगामी के ऊपर बात हुआ, पॉलीगामी के ऊपर एक बात यह है कि हमारे आराध्य जो है भगवान राम है, हमारे आराध्य दशरथ नहीं है, कभी दशरथ की हम लोग पूजा नहीं करते हैं। तो जो हमारे समाज का आराध्य है और एक हमारे संस्कृति में परंपरा है, जो अच्छा कार्य करने वाला व्यक्ति है वो खुद ब खुद भगवान बन जाता है। कोई लास्ट प्रॉफिट हमारे यहाँ नहीं आया। हमारे यहाँ ऐसे लोग निकलते रहते हैं निरंतर जो है। अगर कोई भी व्यक्ति देश के लिए, राष्ट्र के लिए, समाज के लिए अच्छा काम करता है, इसलिए पॉलीगामी हमारे यहाँ अनुचित माना जाता है, ये अयासी मानी जाती है, ये साधन नहीं माना जाता।
But Sanjay sir, is there a question?
I agree with you.
Is there a question? Because we'll then move on. We got the clarification, and I think I said that only. Like he said, his Aradhya is Sri Ram. And then I told you he was trying to get into the traditional concept of what exactly Hinduism is, right?
Absolutely.
Yeah.
I agree with Sanjay ji. जो ये कह रहे हैं कि from that point of view, there is definitely polygamy was always looked down upon. Probably it may have been legal and only it's in 1955, but this is a debate. This is a different debate.
Right, definitely. Yes, Mr. Santosh Kumar Padre is the Secretary General of HCCI. You need to unmute yourself, sir. Just a second. You've been asked to unmute.
Am I audible?
Yeah, you're audible.
Good afternoon, everybody. I started in morning and now it's afternoon. Okay. I have heard everyone, and especially Niharika ma'am was absolutely. I liked her comment. She talked about the political people who are inculcating sense of fear among people. Am I audible? Am I audible, Nihshank?
Yeah.
Yeah,
you're audible.
So actually, what is happening today, that political parties are inculcating sense of fear among people, and rather than whether India is ready or not, I want to put a question whether political parties are ready or not, and I think in our country the questions of common people are hardly heard, and various forums have certain mindset, either left or right. Therefore, my question is, as a community and as a nation, we should improve. And UCC is just a beginning, and it depends on us whether we will we want to go ahead, or just we are looking in our past and in our that
Right,
what we
right,
say.
right.
So thing
Perfect.
is that what should be a right time? It is we are celebrating already
75 years plus.
75 years has passed, right?
That's yeah.
And what should be a right time to improve?
Right.
Everything is changing, and we
Yeah.
should also change as a nation, as a community.
Okay, perfect. I think that is what the debate is about. I think we are already in the consultation phase now. We don't have to wait for the consultation phase anymore. The bios for the speakers are being constantly put out. You can have a look. And now go to Kushank. Thank you so much, Niharika ma'am, for joining us. You really sparked off the debate in different ways. It went in different tangents. And I'm so glad Ananya brought you on board. Thank you so much, Ananya. And yeah, if you have a closing remark, please, you're muted, ma'am. You have to.
I would like to thank you and Ananya for inviting me, and thank you, my fellow panelists, for actually, it was a great thought process. And like I said, maybe now we'll get back to some work now that this is done. And I would also take your leave now and allow me to leave. If there is anything, please feel free to reach out. Thank you all.
Yeah.
Thank you so much, ma'am. It was
Thank
a pleasure
you.
to have you.
Also, we are
It was
happy.
my pleasure to be here.
Madam,
Right.
before you part way, I'll just mention, thankful for your knowledge, which we have today. After discussion, we have deliberated, and thereafter we are able to know much more because we daily learn. But मैं एक चीज कहूँगा कि जो टॉपिक चुना था इन्होंने, अब वो कंट्रोवर्शियल था, लेकिन ये है कि हमारी जो डिबेट है वो कंट्रोवर्सी में खत्म नहीं हो रही. That is the beauty of it.
Absolutely.
Nihshank ने शुरू में कहा था, sir, it's not, luckily it's not prime time, and Nihshank is not going to take sides with the panelists.
Right.
Thank you, everyone.
I think my only concluding remark is we sincerely hope that there will be a draft that can be deliberated upon, and I think all panelists are uniform on that view.
Right. Ma'am, and we are also glad to announce that this discussion is not for nothing. So we have been obviously being made pointers there. There's a team that has joined in. An outcome document of this goes on to the Ministry of Law and Justice as a consultation paper from our end. So that this discussion is, not randomly just happening, and we'll publish a research paper about this as well. So thank you so much for joining us, Niharika ma'am. We'll go on to Kushank because he's been waiting for a while, and then Sukhjinder sir, you can please pitch in. Kushank, please, your comment on consultation with respect to the sunset clause, and we are already in the consultation phase, and I mean I'll just leave the floor open for you because it's been a while, and yeah, please go on, Kushank.
Yeah, I won't take a lot of time, but my concluding remarks are 3-4 things that I wanted to cover. When there was an idea about whether or not the Goa model can be replicated at the national level, etc., etc. See, one thing we have to understand is that Goa comes with its own set of history and baggage, etc. A lot of what happens over there is linked to its colonial past and whatever the Portuguese rule was. So necessarily replicating it might not be the best idea, though of course you can take inputs from the way in which they have worked and see what can be replicated at the national level. So that is one. The second thing is that a lot of what they do is probably built into the, basically we have to recognize the different religions which are there, because the customs over there may be largely Christian in nature. So how do we bring other religions, etc., on board? So that is one question. The third aspect is that when we talk about having a draft, that there can be no discussion in isolation or in a vacuum, granted. But, if you have to have some faith and, there is something called crisis of legitimacy. If you have to avoid that, you have to ensure that even in the lawmaking process, at every stage, the government has to be careful and responsible. So even if you have to have a draft, you can't just produce a draft and then say, okay, fine, everybody, please give your comments. Even the draft has to be drafted after a inclusive consultative process.
Right.
And lastly, I think all of us are on one page or on the same page when we talk about having a sunset clause. And that is, on the face of it, prima facie, with all the caveats, it is not advisable to have a sunset clause. It's not the same as, an arbitration act or an insolvency law or something in the commercial space. It affects people's lives, rights on a very day-to-day basis. So, we cannot have, it's not like selling something in the market and having a pilot project and then replicating it at a larger level. Not everybody can be 100% right. There will be problems, but pilot project experiment, I am totally against it.
Right. I think Kushank, that's points really well made. And I think Pratik Mohapatra is raising his hand. And we've just put out the bio for Pradosh Kumar Mohapatra as well, who, if he wants, can come in here. But Kushank, I think the points with respect to, all the four things are really well incorporated, because we're talking about a, opportunistic proposition masquerading as welfare. For different sects of and communities of people. So let's really not take things for granted, even with respect to the consultative process, the drafting process, and that's really well stated. I think Pratik Mohapatra has a question. You've raised your hand. Please, Pratik, go on.
Yeah, let me know if I'm audible.
Yeah, you're completely audible.
Yeah, hi. Good afternoon to all, and all the best, Nihshank, and good luck for your publication. Really look forward to reading it. See, the thing is, the debate which Kushank was kind of pointing to, being from a background of a digital era, and that what the forum that we are representing, it is more about where are we evolving into. The problem that we had during digitization was very personal to many people, because see, religion and all that is separate, but when it comes to your pockets, I think there is nothing more personal, wherein you have your own status. And with a country like India, wherein you have so many people of different economies and different backgrounds, it affected many people. But what I would like to ask in this evolution phase is, in today, when we look back, do you want to go back to a currency? Do you want to go back to a cash? I don't think so. Many people have also evolved. So I think in the lieu of UCC, I think a civil code is good if it is thought through. But keeping it watertight is like a vaccination shot. It'll pain when you administer it. Yeah, but then it has to be done at some point to bring law and order into a common forum.
Right. That's absolutely well articulated, Kushank and Sukhjinder sir. Your concluding remarks, because is it like the vaccination shot? I cannot see Sukhjinder sir and Kushank on the panel, and we'll lower your hand. Pratik, thank you so much for chiming in. I think Kushank, if you can hear us, yeah. I had a quick question for you. Like a vaccination shot, UCC?
I don't. I think people are looking at it as either a vaccination shot or something. Like what I was saying, that a panacea for all evils. That once you have a UCC, everything in the society will be sorted out. I think we are some way away from that.
Absolutely. Thank you so much for joining us, Kushank. It's really been a wonderful discussion. Ananya, if you want to say something.
Yeah, Kushank, really thank you so much. Your insights that you put in were really helpful, and it helped us understand the debate around UCC better. And I really appreciate your presence.
And I'm glad the evolution also happened. So a lot of evolution on our panel, and definitely when they were writing down the comments, I'm sure our research team is having a very hard time because we've been traveling from one point to another. So Jinder sir, your concluding remark. Thank you so much, Kushank. And we'll end the panel discussion with that. Is Sukhjinder sir on board?
No. I think he's
timed out. Yeah. We'll try and contact him. But thank you so much, Kushank. That is it for our discussion today. Before we wait for Sukhjinder sir, I would really like to thank Mr. Santosh Kumar Upadhyay, Sanjay Upadhyay, Vivek Mohindra, Shweta Mohindra, Reena Upadhyay, and Archie Upadhyay, especially for digitally trying to market the event so well. And we have some of our representatives from different brands as well. We'd really like to thank NYARO for sponsoring the event. And for people who are watching, I mean, not to really flex, but also a little bit, I mean, we have had a great time, right? We had the international guests joining in. We had such a wonderful panel. And the story is not over yet. We have just begun, because we have another session planned out at 3 a.m. and we'll have all the international guests coming in at that point of time. I'll tell you, the names are just incredible, right? I think that's really a surprise because we've not really posted about them as well. But it's gonna be amazing because we'll have people who have a pan India and pan world presence. We're talking about organizations that are established in more than 15 to 16 countries, and the kind of viewership that they bring in is, I mean, a little bit interesting to us as well. So thank you so much for joining us. Thank you so much people who've been working in the background. This is the end of our panel discussion one. Is Sukhjinder sir here?
No, no, no.
I think we'll consider that as his closing remark to what he said to Niharika ma'am, and I'm sure the internet must have dropped down just like the UCC did. Ananya,
Also, one last thing. So for all of you to check out, we've posted the link of NYARO on chat. You all can go check out. I assure you that they have an amazing, amazing collection of clothes.
और करना भी पड़ता है because sponsors, please, let's see. Yes, thank you so much. We'll join you soon at 3 p.m. I think there'll be 2:30 a.m. Back there in United States of America. Thank you so much. Mr. Sanjay, you have your mic open. Anything you want to say?
आज का जो एक हम लोगों का ये बहस था वो बहुत बढ़िया रहा, क्योंकि होता क्या है कि हमारे जो शास्त्र हैं, 6 शास्त्र हैं, पूर्व मीमांसा, वेदांत सूत्र, वैशेषिकी, योग सूत्र और न्याय सूत्र में ये न्याय सूत्र जो है ये हमारे जो डिस्कशन के ऊपर ही बना हुआ है। हम डिस्कशन के माध्यम से भी भगवान को पा सकते हैं, यह हमारे शास्त्रों में दिया गया है। इसमें प्रमेय प्रमाण है, प्रमेय है, संशय है, प्रयोजन है, दृष्टांत है, अव्यय है, तर्क है, निर्णय है, वाद है, जल्प है, वितंडा है। इस प्रकार से हेत स्वभाव, इस प्रकार से हम प्रभु को भी पा सकते हैं। इसलिए यह विषय जो था, इस प्रकार का डिस्कशन, इस प्रकार का हम लोगों में एक सार्थक बात हमेशा चलते रहना चाहिए, चाहे अपोजिशन के हों और चाहे पक्ष के हों, चाहे विपक्ष के हों।
Right, definitely. I'm not sure if we'll be able to manage to reach God by this discussion. We're definitely reaching a lot of media. So stay tuned because around close to 110 media houses will be covering our event. And thank you so much for joining us today. And I think I've thanked everyone else. And thank you to my co-host. We'll see you in session 2. Please stay tuned.